All right, thank you all for joining us today. My name is Ryan Schaller. I'm a title attorney with Gosen and Schaller in Oklahoma City. We're recording today in Durant at Modern Abstract and Title. I want to thank Modern for hosting today and for providing a videographer to record this so you guys can all watch at home. We are doing 3 Cs today, so if you're trying to get your end of the year credit, look out for the other 2 as well. First thing we're going to talk about is the legislative update for last year. We are starting to see 2023 bills filed, but we don't have enough information about them to really talk about them intelligently yet. So we're going to focus on last year. We're going to talk about legislation. We're going to talk about some Oklahoma cases, a Supreme Court case, and then some title standards. Legislation, there's our beautiful Capitol building if you haven't been before. The first bill was House Bill 3381. This was sponsored by Dobrinsky and Moore in the House. Senate was Howard, who is, if you're familiar with our legislative efforts in OLTA this year, he's working with OLTA. What this does is provides an extra option for obtaining service in a lawsuit. So in any lawsuit, you either have to personally serve someone or you're going to have to do notice by publication. Personal service is always preferred. There have always been various ways you can do that, and most of them have involved either giving it to the person or giving it to someone else who lives at their residence who's 18 years of age or older. What this does is allows you to provide that summons to someone at a third-party location. I think what is meant by this is to allow the possibility of serving someone at their place of work. I think that's what's intended by this. Again, this isn't something that you all as escrow professionals and abstractors will really worry about, but as examining attorneys, we have to make sure that all the court cases were done properly, and this gives us one more option for perhaps passing something in some circumstances. Again, the bills last year were not too title heavy, so some of these are only going to be tangentially related to what you do on a daily basis, but they are the most important bills that came out last year for us. This is another one that sort of just amends litigation a bit. If you're an abstractor, you are probably used to seeing foreclosures and quiet titles that start off, and then a month later they file an amended petition. They realize in a foreclosure, they often realize there's a second mortgage they didn't name, or there could be a tax lien or a judgment lien they need to name, so you see an amended petition. Anybody is able to amend a petition at least once. You have all of these options to normally amend. One time for whatever reason, if you decide that you need to add additional claims. Sometimes you see someone and then more facts come to light and you might need to have a counterclaim. So you can do that within certain time frames, depending on what the specific action is. You can go back and do it. And at any time the other party gives you permission to do so. That might seem weird. Why would the opponent give you permission? But sometimes you have what are called friendly suits. If you get money that's from a settlement that goes to a minor, sometimes you have something like that come up where both sides are actually working together. And the final option, and this is what changed, is otherwise a party may only amend the pleading by leave of court. That is the literal language that was in the statute, and no one knew what it meant because it doesn't give you any details. What are you supposed to ask the court? What is the court supposed to consider? So what this bill does is it gave us an answer to that. It added the underlined language. Otherwise, a party may only amend the pleading by leave of court by submitting the proposed amendment with motion for leave of court. So basically that just says that if you need to amend your petition and you need to ask permission to do so, the way you ask permission is by giving a copy of what you want it to look like once it's amended, and then the judge can make that decision. Kind of like with the last bill, this is one that's primarily going to have an impact on your attorneys who are reading title. Because like I said on the last one, we have to know that everything was done correctly. So this is something where it may have been a problem before, but this gives us another option to allow an amended suit to get through. This next one actually is about title insurance. So a lot of legislation has to do with defining things and putting things into categories. The Oklahoma insurance statutes have defined a couple of terms related to our industry. And what they've done with this bill is redefine them. It's a lot of information at first, but I can sum it up pretty quickly after I've shown it to you. So if you start to get lost at first, we'll come back and find everyone. So the statute has a definition of what it calls a customer service representative. Essentially, this is someone that would be someone's job title or the role they're filling. When you're looking at statutes that have changed, the way that they write them is if they underline something, that is language that's been added in by the bill. If they strike through something, that is language that is going away from the bill. What this essentially does is if you have someone who fits the role of a customer service representative, they are now saying they need to be a licensed insurance producer, that TI license that you're getting credit for today, if you have one. So customer service representative was redefined to require a TI license. They took another term in the statute, insurance consultant, which is essentially someone who's not maybe a full-time employee, someone you hire on a contract basis to come in and do some work or to help. That kind of person is also now required to be a licensed insurance producer. So the point of this statute was to take those two terms, customer service representative and insurance consultant, and say that if you're functioning in either of those roles, you need to have you need to be a licensed insurance provider, which is the TI license in our field. So the third thing and final thing the statute does is it completes the circle. We redefine customer service representative and insurance consultant to include you need to have an insurance producer's license. What this does is it takes the definition of insurance producer and says this definition now includes those other two terms that we just defined. My interpretation of this statute, and I've given this presentation 4 times without anyone telling me I'm wrong, so I think I'm right, is that this means that if you're working in the title insurance industry, you need to have a license. I think this is meant to try to eliminate people not having licenses and maybe getting away with it by just saying they're just there to help customers. I think the point of the statute is the safest scenario is to get everyone on your staff licensed for title insurance, unless they're truly just maybe reception capacity or something like that. Again, there were some more changes in this statute, but they all relate to the same thing. Once you change the definition in one place, you have to make sure it's consistent throughout. So we're not going to take the time to look at every single specific word that changed. But the main impact of that is I think that everyone working for a title insurance company and working with people needs to have a license moving forward. So this one is kind of fun for me to explain. I don't know why. We're going to talk about probate for a second. And you guys are lucky, I said every time I did this earlier this fall that I was going to revise these and simplify them, and I finally did it yesterday. So, and when you go and get estate planning done in Oklahoma, you normally get a packet of dockets given to you, given to you. And what you do is you execute a trust. You guys are familiar with seeing trust and title. You execute deeds conveying your property to that trust. You also normally get a power of attorney for if something happens to you later on. And the final thing you do is called a pour-over will. If you don't have a trust, your will is probably just going to say, I want my spouse to take this, I want my kids to take this, everybody shares equally. But if you have a trust, your goal is to avoid probate. You don't want to have to put the will to probate. You paid the estate planning attorney to try and get around that. So the pour-over will is used just in case you acquire property after you finish your estate planning and forget that you're supposed to put it in your trust. That's essentially when a pour-over will comes in. So in this hypothetical, so if any real property is not conveyed to the trust, under a pour-over will, you would take it to the judge would admit it to probate like any other will, but instead of distributing the property out to your children, your spouse, your heirs, it goes straight to that trust you created. It's supposed to work great, but sometimes things get complicated in real life and it gets messy. And this bill is designed to clean up some of the messiness. I think it's a good bill. This is another Senator Howard bill, by the way. So under this scenario here, let's say that back in 2015, I create a revocable trust. On that same day, I create a pour-over will that says anything I forget to put in my trust, I want to go in my trust when I die. Everything's great at that point. I put my house in the trust. A few years later, life changes. Maybe I have more property. For whatever reason, I decide that I want to amend my trust. Maybe I don't like the people I put in charge of it before. Because like most people, I don't want to spend another $700, $800 on a will. I just get the trust redone and I don't have my will updated at the same time. So what that means is that I have a will that says, if I die with any assets still in my name, they go to the RS Revocable Living Trust dated June 3rd, 2015. But that trust no longer exists because I changed it to the amended and revised trust dated August 1st, 2020. So a probate court, following the letter of your will, would say, the trust you describe in your will does no longer exist. Therefore, we're going to use the power of the court to create that as a testamentary trust and put your assets in it. Because that's exactly what your will says. Even though you've moved on and done a new trust now, your will still names that old one. So this created a big title problem because you'd have people who had a trust set up, and then you'd have a judge telling them, oh no, you need to set up this other trust because it's literally what your will says. What this law does is allow you to eliminate that problem. It puts language into our will statutes that allow the court to make the reasonable inference that that 2015 trust that was amended into the 2020 trust is the same trust from your pour over will, and it can put those assets into the amended trust without making you create the old one and deed from the old one to the new one. So what this is meant to do is, and again, this is one of those situations that doesn't come up often, but when it does, it's really frustrating. And it's designed to eliminate the headache caused by this sort of inconsistency. I haven't had a chance to use it yet. I haven't had a fact scenario come up where I've been able to apply this, but I'm sure at some point it will. Because people change trust all the time. You see all those memorandums. You're familiar with that. So we're going to continue talking about probate. We had two really big cases in title over the last few years that occupied about 90% of the Title Examination Standards Committee's time. First one, and this one has been resolved now thanks to legislation. Again, Senator Howard is a lawyer, so he's a good lawyer. He's got an LLM in tax, so he does some good legislation. What happened in the Walker case? Someone died as a resident of Mays County, which is far north Oklahoma. The decedent was also an Osage Indian, and he left real property interest in Osage County. The Osages hold their mineral estate differently than the tribes do down here. Instead of allotting out individual shares, you have what's called a head right. And so the nation as a whole leases the entire mineral estate, and then the individual members get a cut of that. So it's not like, so when you're probating an Osage Indian's estate, there are some interesting things to it that you don't do in other parts of the state, which is why I think the lawyer originally filed the probate in Osage County. So he filed it in Osage County where the property was located, but the person lived and was a resident of Mays County. The traditional interpretation of Title 28, Section 5 would require that the probate be filed in the county of residence, which would have been Mays County. If it's not filed in the right county, then technically the court never had jurisdiction to hear it, which is not a curable problem by the passage of time. So that was this case really terrified people on title standards. Because what happened here was, we'll get to the holding, but so the court had to decide, because this is a proud moment as a title attorney. What happened here was a title attorney noticed that it was opened in the wrong county and made a requirement. And if you really want to be famous as a title attorney, create a Supreme Court case. One of your requirements. I've only done it once. But so what happened, the wife appealed because she was supposed to have all this money. And what the court ended up saying was, yeah, you can file it wherever you want. And so it didn't get appealed from there because everyone was happy with the result, but except for the other lawyers. So the traditional version of, and I'll explain that in more detail. That was kind of a preview. So traditionally under these statutes, if someone died, the first place you would probate them is their county of residence. If someone died who was not an Oklahoma resident, you would probate them where the property is located. If you're on a state line, you probably have a lot of people who live in the other state, but their property might be located in this county in this state, so this county would be the appropriate place for an out-of-state person to be probated. Anyway, we had this list of 5 things. 3 and 4 are kind of confusing, and the law has changed. That's not the current law, so didn't put them all up there. So this is the last look at the old law. So when it was first passed 30, 40 years ago, the statute language said first, written out, second, written out. In 2018, when the court heard the Walker case, they went on OSCN, and the statute is now numbered 1, 2 instead of first, second. So the court read into that and said that the change from first and second to 1 and 2 was a purposeful amendment to remove any of the preference of where to file it, the priority, and that you can therefore file it wherever you want. So that was how the court interpreted this, all because of the change from first and second to 1 and 2. So title attorneys were really bothered by this, and so they kind of researched it, and it found out that the legislature never changed the language from first, second, and third to first to 1, 2, and 3. West Publishing did that, Thomson Reuters, when they were putting the statutes online. I have a friend who works for them. I give him so much grief over this. And so they just did it as an editorial change. That wasn't a purposeful legislative change. And that's what the title standards attorneys found out afterwards, and they just flipped out. There was a big fear among rural attorneys that all of the probates were going to get snatched up by attorneys in Oklahoma City and Tulsa, and they were just going to file them there. You don't want to file a probate in Oklahoma or Tulsa. It takes forever. It takes twice as long as it would down here. So I think that was an unjustified fear that horrible things were going to happen. I've only known of 1 or 2 cases that were filed in the wrong county under Walker. And it's not something that happened a lot because attorneys don't pay attention to changes that often. So I think this was fixed before a lot of them realized that it gave them more leeway. So again, that's just some more information. This was actually a Court of Civil Opinions decision and not a Oklahoma Supreme Court. So that makes it slightly less authoritative. So some people said we should ignore Walker because of that. However, this last year, the legislature fixed what happened in that case. And so we have a new law now that's very straightforward. We're really, again, only going to focus on the first parts of it. If a decedent dies as a resident of the state, so if an Oklahoma resident dies in Oklahoma, the county where they were a resident at the time of their death is where the probate should happen. Now, in the old statute, there was a reference to if someone dies in a different county than where they live, you can probate it there too. They got rid of that. Now they added, regardless of where the person died, you probate them where they were a resident at the time of their death. So if you live in, Okfuskee County, but you have to go to Oklahoma City for the hospital and you die in Oklahoma City, you were still a resident of Okfuskee County. If you have a decedent who dies outside of the state, you're looking to see what county in Oklahoma they own property. So if you are, on a border county or something like that, and someone gets probated in another state, you're trying to figure out where's the property located in Oklahoma. And we will talk about probate in a lot more detail on one of the other presentations today. So we're just going to kind of move on from this. This is just some more information that your examining attorneys will take into account. These are really contingent scenarios the further you get down this list. The important thing about this new statute is it creates a safe harbor. If you're a title attorney, you love safe harbors because that means after enough time has passed, it can't be challenged anymore, so you can waive the defect and just move on. So what this bill says is that if someone mistakenly filed a case in the wrong county because of the Walker decision, if no one has challenged it or tried to file another case in a different county within 1 year, then we're just going to grandfather in that probate that was done in the wrong county, if it was done during the Walker period. So this just sort of says, hey, if you did it in the wrong place during that messy time period, if no one's challenged it, we're going to call it good and move on. Last statute we're going to talk about today, but it's very much about cases. So the Walker case was one of the big cases that bothered title attorneys recently. The other is called the Schweigert cases. So traditionally under Oklahoma law, if you filed a lawsuit and properly served a notice, we've talked about a couple of service things earlier today, but if you properly serviced all of the defendants according to statute and court rules, and the defendant does not show up, does not make an appearance, does not file anything within the time period, you are automatically granted a default judgment against the defendants. You didn't need to file anything special. You just showed up to court with your journal entry of judgment. The judge would generally call their name out one more time, make sure they're not there, and they sign your default judgment, and you're done. go file a copy in the land records, and you can move on. That is how things were done for decades. A series of Oklahoma cases that started in around 2014, 2015 changed this. Depending on what part of the state you're in as you watch this, you might be very familiar with this. In the areas where I examine, I think I've successfully browbeated all of the attorneys into understanding this is a thing now. Oklahoma City and Tulsa, generally on it too. And we will get to a statute related to this eventually, I promise. So the Schweigert case was a Shawnee County divorce in 2015. When you go to law school, they teach you a kind of a maximum your first week that if you have a very weird and peculiar set of facts, the court is going to make bad law from it because they're trying to find the best answer for that circumstance, but then people want to apply it more broadly afterwards. So what happened here, if you've ever been in court, especially county court, they call your name out when your name's up on the docket. Usually if you're not in the courtroom, someone will stick their head out in the hall, say, "John Doe, are you here?" They're called 3 times. And if you don't, they hold you in default. So what happened in this very peculiar case, husband was in the courtroom before they called his name. Then someone told him his car was being towed, so he ran out of the courtroom to go get his car, and then they called his name and he wasn't back, so they held him in default. So that was a really weird set of facts, right? He was there, he shouldn't have been in default. So instead of trying to do a very narrow ruling that applied to that set of facts, they said, the Supreme Court of Oklahoma, that a motion for default judgment must be filed in all instances. So attorneys hate this when I point it out to them because it's not how they did it for the last 20 years. I've tried to move into a more gentle approach and say, I understand how frustrating this is. I don't agree with the cases either, but it's what the law says now. So I was actually assigned by a former employer back in 2016 to research the Schweigert case. And at the time, we kind of said, Schweigert's a family law case. We deal with real estate and title. We don't care about family law rules. We're just going to ignore it for now. No one did anything. 2018, there was another case. It's called Asset Acceptance v. FAM, and it has a similarly stupid set of facts. The FAMs bought a big television entertainment center piece of furniture from a rent-to-own center. When it was delivered to them, it got banged against a wall and put a scratch on it. According to the court pleadings, there was an oral agreement between the delivery people and the FAMs that they didn't have to pay like the last $40 of the thing to make up for the difference. So the FAMs paid everything off except for that $40 they were told they didn't have to. And they just stopped responding to payment requests after that. As far as they were concerned, they were done. So they got sued. FAMs never showed up in the court case, never hired a lawyer, never filed anything, but they sent so many letters to that law firm, just arguing about why they shouldn't have to pay it. Law firm goes to get their default judgment and says in their statement that they never heard from the client. It's just from the other side. It's a normal statement you make in your default judgment because that's what happens 99.9% of the time. This was extremely weird circumstances because they had reached out to the lawyers so much outside of the court. All of that came up on appeal. And when it was up on appeal, this was actually the Oklahoma Court of Civil Appeals this time instead of the Supreme Court, but they quoted the Schweigert holding and said that a motion was required anytime a default judgment was acquired. At that point, a couple of the larger foreclosure firms based out of Oklahoma City started filing motion for defaults after the FAM case. Title attorneys were still a little split. That was a case about a debt. It wasn't a case about real property. 2020, a case out of Enid, Southwest Casing v. Foster, applied the Schweigert ruling to a real property case. It was essentially a standard quiet title in Garfield County. So those of us who are active in title standards and do a lot of stuff like that, we started making requirements for default judgment in 2020 after the Southwest Casing case. That's when we all started doing it. Again, I mean, if you've got examiners who've been doing this for a while, I know where I examine, I've gotten most of the people on board with doing this now. They understand it's a requirement. Some people in the Title Standards Committee have put together very great presentations I can share if people have trouble admitting this, but it's the law now. And people have tried to fix this so hard. I keep getting roped into reading the bill and commenting on it. But Representative Kennedy is a lawyer from Oklahoma City, and he has every year for the past 3 or 4 years now brought a bill to fix the Schweigert ruling that would basically take us back to the original default judgment rule that everybody knew for decades. It has passed the House 2 or 3 times, but it always dies in the Senate. The issue is that even though I don't want to say I've been asked to read it, but I'm not part of this, that even though they're just trying to get the law back to the way it was, it doesn't smell good because you've got people who are being sued for debts and you're saying, well, we don't need to send them a motion that we're going to collect against them. So it just has a bad taste in the mouth to try to take that away now that it's been established. And I think that's why there's been some resistance to getting it passed. Although the senator who was in charge of the Judiciary Committee the last few times has changed. So I think there's some optimism that with a new Senate Judiciary Chair, that might get a little further this year. Otherwise, I think most lawyers are starting to understand that this is a thing now. I used to have to make this requirement a lot. I can go months now without having to talk about it. So that bill did not pass. Hopefully it will this year. We're going to talk about a few cases now. So WSP, H2K Technology, H2K Technologies versus WSP USA. So this is a mechanics and materialman's case. I'm pretty sure this was an oil site. A lot of the really, really big M&M lien cases are work done on oil rigs. But what happened here was that there was an original contractor, WSP, who contracted with the landowner. In that contract, WSP waived their right to file a mechanics or materialman's lien. They said they wouldn't do it. They had all this. I haven't read the contract, but that was what it said. Now, WSP hired H2K as a subcontractor. The agreement between the contractor and the subcontractor did not repeat the lien waiver clause. So the argument was that the subcontractor had no knowledge that it existed. So after the work was done, the subcontractor, H2K, was not paid. So it filed an M&M lien against the property owner. WSP got brought in. That's why they're the defendant, and you don't actually see the property owner's name on that. So they had a fight over whether H2K was allowed to put that lien on or whether they were prevented. And it's important to point out about appellate cases, they don't interpret facts so much as they talk about issues of law. So what happened here was they said, if we take all of the facts as true, there is no evidence that H2K knew about the lien waiver, therefore it's not held against them. Now, what they did say was discovery had never been done. Discovery is the part of the lawsuit where your lawyers get to ask the defendant to turn over all of their documents, various things like that. So what the court is essentially saying is that they sent this back for the court to look at again, said if the subcontractor really had no knowledge of that, then they weren't prevented from filing their lien. But they wanted the court to look through discovery to find out if they had actually maybe been told at some point. They were leaving that possibility open. So the main point to take away from that is just because you have a lien waiver in your primary contract doesn't mean that it will automatically carry over into subcontracts. Second case, this one was a personal victory for me. I wrote the COVID-19 standard in the title examinations handbook, and this case basically said we got it right. McBee versus Shannon Home Design. So what happened here was someone was building a house, tons of houses being built lately, or back around 2020, 2021. And once you file a case, you have 180 days to serve the other side or your case goes away. You can't just file a case and leave it sitting. You got to do something. And the SCAD order, so what happened during COVID, you had 3 separate, they're called Supreme Court advisory decisions, I think, or administrative decisions, and it's abbreviated SCAD. And what they said was all deadlines are told during the pendency of this order. The way we interpreted that on title standards was if you have an 180-day deadline and the court was closed for 40 days, that 180-day deadline gets pushed back 40 days. That's how we read it. That's how we interpreted it in the title standards. Apparently, the district judge in this case didn't interpret it that way. He threw out the case. He said you had 180 days. That was plenty of time. But they appealed, and they won the appeal because the appeal said, no, we told it. They had 100 or 220 days now. You add on that extra 40 days to the total. That is probably an issue that will be watched around this time, but I imagine within a couple of years, we're not going to care about that at all anymore. But that could be something that's important with cases that were interrupted by the COVID shutdown. This is a Broken Arrow case that relates to zoning. McCleary kept an RV in her driveway. It was, I believe, used to clean dogs. I think it was a mobile pet cleaning, something like that. And Broken Arrow has a lot of ordinances. But Broken Arrow has an ordinance that says you can't park your recreational vehicle in your driveway for more than 24 hours. Now, for the most part, zoning is accepted from title. We're going to talk about that in the second presentation today, unless you're getting zoning coverage. But this is still related to us, so we want to make sure we understand it. So her argument was, you can't fine me over this because the purpose of that ordinance was to keep people from parking their RVs and, getting old and dirty. Mine's a business. It's not intended to be covered by this ordinance. Court said, no, thank you. And this is the important takeaway from this case, is it doesn't matter what it's used for. The definition in the zoning code of what is an RV doesn't talk about use. It's a definition of what it is, doesn't matter what you use it for. So the definition controls. Her RV was not exempt. This is another somewhat interesting case that I think there are a few title attorneys who I believe think they got this wrong. I mentioned property disclosures, I think earlier on, just as a tangent comment. But so if you own residential property and you sell it, you fill out that real estate disclosure thing, what's wrong with the property. The fact situation in this is that mom and dad died. One of their brothers and sister-in-laws were the successor trustees. There were teenage children still living in the house. They would be the wards, or their aunt and uncle were going to be taking them in. Aunt and uncle sell this house, turn in a real estate disclosure statement that shows nothing on it. A house gets sold, people move in, and immediately find water damage that I guess was missed during the inspection. But there's a lot of problems. This is what always happens in disclosure cases. Someone calls a plumber, they come out and they say, oh, I told the people about this 6 months ago when I was here last time. That's how all of these things get started. And so they're like, well, you knew about this. You should have told it. You should have disclosed it. It should have either been, we should have had the option to have it fixed or to back out of the contract. The trustees' argument was they had never lived in the house. They were only doing a fiduciary duty, and therefore they had no knowledge of what the problems were and weren't responsible for disclosing them. The court agreed with them. The court held that this was no violation of the Real Estate Disclosure Act. They were exempt from it. This was talked about in one of my real property groups. There are a couple attorneys who really latch onto the fact that the niece and nephew were living in the house and that it was their aunt and uncle who sold it, and that if there was active water damage while the niece and nephew were there, they probably knew about it when they sold it. So there are some attorneys who really aren't happy with this result. I think it makes life easier for me. And that is the last state case. I think we've gone about 35 minutes, so we're about on time here. We're going to talk about McGirt for a little bit. Everybody excited about McGirt? So as a recap, the McGirt case involved a crime committed by a Native American on land held to be Indian country. I'm actually got a map on on my last presentation today, and we'll see a map of Indian country versus regular Oklahoma territory. But so in McGirt, the defendant was ultimately released and then retried by the state afterwards. But the holding in McGirt was that if an Indian committed a crime on Indian country, the sole jurisdiction for prosecuting that crime was the federal government or the tribal government. You guys have all been in Oklahoma for a while, so you're aware that McGirt was a big deal, scared a lot of people. So to talk about this next case now, in Oklahoma versus Castro Huerta, the defendant in the case was not a Native American, but he was, I believe his girlfriend was Cherokee, and she had a child who was a Cherokee Indian. He appealed his conviction for child endangerment and neglect. And while that appeal was pending, the McGirt case came down from the Supreme Court. Following McGirt, the Oklahoma Court of Criminal Appeals vacated Castro Huerta's state court conviction, meaning that he was immediately rearrested by the feds, though, so he didn't go free. But so he appealed. He said, hey, this was on Indian country and the victim was an Indian. Doesn't matter that I'm not Indian. It should have been by the federal government. And so that was his basis for appeal. The state challenged that and pushed it back up to the Supreme Court. And so the question that Supreme Court cases are frustrating to read because they're all like 60 to 80 pages and only about 5 pages of it are actually the holding. So you have to get through a lot of other stuff to find out what they're actually talking about. But the issue in this case was, under current federal law, does the federal government have exclusive jurisdiction? Exclusive would mean they are the only ones who can do it, to prosecute crimes committed by non-Indians against Indians in Indian country? Or do the federal government and the states have concurrent, which means either one of them can prosecute the crime? So the holding was that they have concurrent jurisdiction in the specific case of a crime committed by a non-Indian against an Indian in Indian country. So that is a specific narrowing and limitation of McGirt on a very specific criminal law question. People, I think, want to put some faith in this because the makeup of the Supreme Court changed between McGirt and Castro Huerta. So I think the fact that they found concurrent jurisdiction in this gives some people some optimism that maybe future cases will continue to limit the impact of McGirt. But I don't think Castro Huerta on its own is really going to impact what the title industry does on a daily basis. It's very, very tied into the specific criminal case. So what happened, he was a federal jury charged him, indicted him for the exact same conduct. He agreed to a 7-year plea deal. He was not a lawful U.S. citizen, though. So after his plea deal, he was removed from the U.S. Not sure where he is now. But so that's the end of that story. So he did get put in jail, and then he got shipped out of the country. So there was some justice in that one. Title standards. We have 2 title standards we're going to talk about. This one I also helped with. You never want to express an opinion in a title standards meeting because you get assigned to the group. You get put in charge of it. So transfer on death deeds, I think everyone understands that these are complicated and they cause headaches. They're fairly new. I think they first came out about 10, 11 years ago. Important thing to realize about the Todd statute is it was designed so people didn't have to go to attorneys. So that is why it's so poorly worded. The idea, it was pressed by an interest group who didn't think its members should be paying for estate planning, so they wanted an alternative. So transfer on death deeds work in extremely, extremely limited circumstances. Well, they work well. If you have, one of the ones I drafted was a woman who had cancer, who had 3 children, 2 of them had disappeared, one of them lived with her and took care of her. We did a transfer on death deed from her to that daughter, one person to one person. If you put more people on either side, it starts getting really complicated and you run into a lot of problems. What a lot of people want to do now is they want to do husband and wife, grant a Todd to all 3 or 4 of our children. And that gets problematic because one end you have the question of, well, what happens after the first person dies and the second person is still alive? We're not going to cover that. We haven't made up our minds on title standards yet. The second question is, what about those 3 people who are named as beneficiaries? Does every single one need to sign an acceptance? Can one person accept on behalf of everyone? That's what we do with affidavits of surviving joint tenant. You know, generally they're just 2 people, but if you have 4 people as joint tenants, only one of the surviving 3 needs to sign it. Not all 3 do. So, you know, some people made that argument, said, well, you know, we do it with affidavits of joint tenants, so anybody should be able to do it here too. So one of the questions that I think people don't think about is, what are reasons that someone might want to reject property that someone's giving them? You know, because you got to think, if we're going to force people to accept property because one person signed an affidavit, what are the consequences? The big thing about TODs is they pass subject to the mortgages and liens attached to them. If your property goes through a probate, the probate court generally strips those liens because they become attached to your probate estate and have to be paid out of the probate. Again, you'll get mortgage payoff statements sometimes. Technically it's a different thing, but it looks the same. So the property passes subject to the mortgages. So let's say it's a $300,000 house and mom still owed $250,000 on it. Maybe you've got your own house and your own mortgage you can barely pay. Do you suddenly want to inherit a third of mom's mortgage just so you can keep the house? Another one is judgment liens against a beneficiary. If you have a judgment against you that's still valid, the minute you acquire property, it attaches. So if the plan is that, Sally is to get mom's house and she's going to buy Jim and Joe out of their interest, if Jim's got a $100,000 judgment against him, that's going to attach to the property as soon as the TOD beneficiary affidavit is filed. This one I used to see, beneficiaries in bankruptcy. For a while, I kept seeing files where elderly people would put their children in title with them as joint tenants. And I swear every single time one of the sons was in a bankruptcy. Had this happen like 5 times a few years ago. It was a while back. But if one person goes into bankruptcy, then that sort of screws your whole transaction up, because then you have to wait and get bankruptcy approval to get their 1/4 interest out. The other big issue is Medicaid. If you suddenly get a windfall inheritance, that could screw up some very careful Medicaid planning. I don't do that myself, and I don't understand the details, but I understand a lot of work and planning goes into that eligibility, and suddenly inheriting a large piece of property could throw a wrench into that. Again, there are also tax concerns. So again, if someone is going to lose Medicaid eligibility, should we allow a different person to accept on their behalf? That was kind of the main line of thought. And we looked at the way the statute was written. We looked at how TODs were treated in other jurisdictions. And so we ended up coming up with this new standard. And I always like to point out to people who aren't in title standards is we don't pass things quickly. And we don't pass things by simple majorities. We've had one topic that's been going on for 4 years now, and depending on who shows up, it wins like by 2 votes one way or the other each time. But we won't pass that because we want it to be a consensus of the whole title examination standards committee. We don't want it to be just one more person agrees with this than doesn't. So this had unanimous consent from the people who voted on it, who were there. And basically what we said is to accept the transfer of a conveyance to multiple grantee beneficiaries in a transfer on death deed, each individual beneficiary must accept and record the affidavit affirming the acceptance of the conveyed real property interest under the transfer on death deed. I believe that's how most people were already doing it. There's one pocket of the state that's very problematic with these. It's very far to the north. But most of the people, I think, were already on board with this, and it's basically just a statement of how most title attorneys were already treating them. So we put comments to explain what these things mean. So comment 1, all beneficiaries must execute and record an acceptance in order to receive their respective interest under a transfer on death deed. As an example, A executes a transfer on death deed naming X, Y, and Z as beneficiaries. X and Y execute and record the acceptance affidavit, but Z does not. In this situation, only the 1/3 interest that would have gone to Z reverts to A's estate. And that's very clear in the statute. If the statute doesn't talk about what multiple grantees, but it says if grantees do not accept, what is not accepted goes back into their estate. So that means that it's possible that Z may not get anything. If there's a will and the will says that X and Y are the only heirs, then Z's share would go back into A's estate, and it may be ultimately distributed to other people, because once it's in the estate, it passes subject to their will or intestate statutes. So that's just, again, that's why a lot of lawyers are really hesitant about passing about drafting these in the first place, because we realize that it could create problems down the line. So again, this doesn't say it in here, but there is a statutory period that you have to accept by. It's 9 months from the date of death. So if you have 2 people, I think that's stated in another standard, that's why it's not part of this one. So if you have 2 people who've signed affidavits, within the 9 months, but a third who doesn't, that third is out of luck now. It is also irrelevant whether they sign one affidavit or more. So if you need to get affidavits from 3 different beneficiaries on a TOD, all 3 of them can sign the same affidavit. If one's in Massachusetts, one's in Texas, and one's in California, you can send a separate affidavit to each of them and they can each sign their own. What counts is that they all sign something, whether it's one acceptance or separate. So this actually was passed 2 years ago, but it was left out of the handbook last year. So we're going to talk about it now. Should be getting new handbooks within a month. They usually come into January. Title examination standards, we have our first meeting this Saturday, if you read the title standards, you'll notice there isn't a ton about Native Americans in there, which is surprising considering half the state is Indian Territory. I think part of that is because people couldn't agree on how to treat restrictions across the strait for a while. But there is now an active subcommittee that is working on nothing but Native American interests. Some very talented attorneys on there. I'm not on this one personally, thankfully. So what happened? They're working on determination of heirship and some other things. But what this standard specifically did was, and we are going to talk about Native issues in my second presentation today. But the Stigler Act was something that went into effect in the 1940s. And what the Stigler Act said was that any time a state court administered the estate of someone who was less than half-blood Native American, then the restrictions were automatically removed. So again, this is something, very beneficial 60s, 70s, 80s. You saw this thing a lot. A lot of original Aussies, might have lived into the 50s or 60s. And oil and gas people were really big about this too. But so what happened in 2019 is, and this was actually before McGirt, the Congress, led by Oklahoma's delegation to Congress, decided to change the Stigler Act and amend it. The tribes were getting tired of losing land, losing it out of their jurisdiction. So what they did was they undid the Stigler Act effective January 1st, 2020. So if someone's restrictions had not automatically been removed by 2020, you no longer have the automatic renewal. I think this is a very limited circumstance thing because this would have to be someone who still has restricted property in 2020. This doesn't go back and re-put them on anyone. This would only relate to people who've never had their original restrictions removed. It's 2020. Those people aren't alive for the most part. So I think this is more just a recognition that the law moving forward changed. We added a caveat to the standard saying you can't rely on the Stigler Act in probates that happen after January 1st, 2020. Still rely on it before then. And again, I think the number of people this will apply to is very low. I also think it's more of an oil and gas thing because oil and gas mineral interest, they're not always covered on those patents and removal restrictions. Sometimes they're very specifically only to the surface. So the oil and gas title people spend a lot of time relying on this because there just weren't as many quiet titles that were specific about oil and gas rights. So again, this is a big change. I think it's going to impact a lot of oil and gas people, but I don't really see it being a big change in the daily business of examining surface title, but it is a change. And that is my last slide for the first presentation today.